The Order of Nature. Issue in Navtej Singh Johar vs. Union of India. Whether Sec. 377 of the Indian Penal Code 1860 is violative of Article 14, 15, 19, and 21 of the Constitution of India, contentions of petitioner and others. The contentions raised by the lulled Senior Counsel Mr. Arvind Datar on the behalf of petitioners were as follows. 1. The sexual orientation of an individual is a natural and private expression of choice and freedom, rooting from the consent of two qualified adults. Francis Coralie Mullen v. Administrator, Union Territory of Delhi, 9/2014, 9 SCC 1 and others. 2. The fact that it is criminalized in itself flouts the principles of dignity and autonomy. It is an essential characteristic of one's private life, where an individual is entitled to the right to reputation, option to shelter, and choose a partner. Sec. 377 IPC is violative of Article 14, as the term is indistinct and does not define carnal intercourse against the order of nature. Furthermore, there is no intelligible differentia or reasonable classification that exists between the natural and unnatural sex, as long as it is consensual. 4. Anuj Garg and others, vs. Hotel Association of India and others. 5. Sec. 377 IPC is violative of Article 15, as there is separation based on sexual identity and sexual preference of an individual. An individual is prosecuted under Section 376 C2 EIPC for committing an act with the opposite gender without her whereas if similar acts take place out of consent between people belonging to same sex is condemned. 6. Sec. 377 IPC disregards the privilege of the LGBT people under Article 19(1)c, denies them the option to form affiliations, and furthermore, a conviction under Sec. 377 IPC renders such people ineligible for appointment as a director of an organization. 7. Sec. 377 IPC also incapacitates their growth in terms of personality and relation-building endeavors to enter into live-in relationships, standing in violation of Article 19(1)(a) of the Constitution. 8. Fundamental rights are accessible to all citizens of the country, including the LGBT community, which comprise 7 to 8% of the Indian population, constituting a minority. Such individuals need more protection in comparison to heterosexuals. Hence, they should be entitled to the same benefits and rights arising from a live-in relationship, such as testamentary rights, medical treatments, choice of partner, and insurability as laid down by Indra Sarma versus VKV Sarma. 9. 8. The rights of LGBT, as perceived under the NALSA judgment, where the transgenders have been recognized as the third gender but still any sexual act amongst them would remain an offense under the given provision, and the LGBT stand in a vulnerable position, where their choice of sexual orientation isn't permitted and draws criminal attention if expressed due to lack of constitutional protection. 10. 9. Sec. 377 IPC is arbitrary, as it makes the consensual relationship a criminal act on the ground that it is against the order of nature. Shayara Bano v. Union of India and others, and is against the idea of fraternity as embodied in the preamble of our Constitution. 11. 10. The decision in Suresh Kushal and another Vinaz Foundation and others are per incuriam, as it failed to take into consideration the amendment to Sec. 375 IPC, which rendered sexual, carnal intercourse against the order of nature between opposite gender permissible, whereas it still continued to be an offense for same-gender consensual intercourse. 12. 11. Section 377 IPC impedes the LGBTs to understand their rights with regard to shelter. They look for the help from private sources such as Gay Housing Assistance Resources, GHR, so as to get to the safe house, which means that these individuals are in scathing need of quick consideration and protection by the state. Contentions of the respondents. 1. There is no concept of personal liberty in abusing one's organs, and that the hostile act restricted by Section 377 IPC is committed by abusing the organs. Such acts are undignified and critical to the protected idea of liberty enshrined in the Constitution, and if any infraction is caused to the idea of dignity, it would tantamount to constitutional wrong and constitutional immorality. Section 377 IPC isn't violative of Article 15 of the Constitution, as the said article forbids separation on the grounds of just religion, race, caste, sex, place of birth, or any of them, however not on the basis of sexual orientation. 3. Section 377 IPC in its current structure doesn't disregard Article 14 of the Constitution, as it simply characterizes a specific offense and its punishment, and it is well within the purview of the state to figure out who ought to be regarded as a class for the purpose of the legislation. For the issue, the